Copyright in these lectures is either owned by the ANU or a third party who has licensed the ANU to use it. Students may use the recording for personal study only. No lecture may be communicated online, copied or shared without the prior permission of the ANU.
All right, we're a little bit down on numbers. I suspect this is the curse of the midterm papers and midterm exams, which happens about this weekend every semester. Very good. So we'll just have to press on. We'll see how we go as far as how much material we get through. I'm reluctant to try and get through too much if not all students have the opportunity to be here, but we have to get through it all. So tonight we're going to finish off the lecture from last week, which was about directors' duties. So last week, at the start of this lecture, we covered the two, if you like, the two duties at section 181, the duty to act in the interests of the company and the duty to act for a proper purpose. We also talked about insolvent trading last week as well when we finished the other lecture. We had just started our discussion of sections 182 and 183 of the Act, which are so section 182 and 183 where the Corporations Act has codified the duties around conflict of interest. So the common law duties, and remember as we've gone through, we've noted that there is the statutory duties have come from the common law or from the courts of equity. And so sections 182, 183 codify these conflict of interest issues, so the duty not to misuse their position and not to misuse information. And so we'll go through section 182 and 183 in more detail in a moment, and we'll also pick up on section 191. But we're just talking about some of these scenarios where conflict of interest has arisen. So we looked at a few of the cases last week. We looked at Fur and Tomkeys, that takeover case, that conflict of interest. Looked at the Green and Bestabel type of scenario, as well as the Aberdeen Railway case. Now we're going to start the conversation of a fairly large area of conflict of interest, which is the common law described as taking the corporate opportunity. So for our purpose, we could still start our discussion of it under section 183, but this is how it's arisen under the common law. So the first case that we'll look at there is the case of Cook and Deeks. In some ways, I should mention too, with the corporate opportunity, the reason we'll probably spend a little bit of time is just to try and get our head around what it actually involves and try and see where some cases the courts have taken the view that it was a conflict of interest, and other cases that look somewhat similar, the courts have taken a different view. So we'll try and get our head around why the courts have taken the view they have. And the best way to do that, I think, is to look at the checklist, and I'll put a checklist in there as well to think about what the courts have had regard to. So looking at the case of Cook and Deeks, this case involved 4 directors. Three of the directors sort of sided together, and they are in dispute with the 4th director. So we've got the 3 directors who had 75% of the shareholding, the 3 directors there. And they were all directors of a company called the Toronto Construction Company. They were putting in a tender for a large project that they wanted to get the work, so they get a really good pay. So the 3 directors were negotiating this major project deal. But as I noted, they'd had this falling out with this 4th director. So what did the 3 directors do? They created a new company. And they said when they submitted this tender, they said, we're putting in this tender, but if we're successful, we would like you to give the contract to this new company. And really what they were trying to do, might think of it as diversion of business. The company that they were the directors of had an opportunity, and they were trying to give that opportunity to this other company, this new company that they created, but in the process they were excluding this 4th director from the deal, or getting any benefit from the deal. The court held that this was a breach of the fiduciary duty. They had placed their personal interest, which involved taking a corporate opportunity, which was the right to build the new railway line, above their duty to the Toronto Construction Company. And the key point here to make is that the taking of the corporate opportunity was quite deliberate. So it's a clear example. So the opportunity really did belong to the company. Okay. We'll come to the Peso Silver Mines case. In this case, we had an offer had been made to the board of a company called Peso Silver Mines. So there was an opportunity as such. The board rejected that opportunity in good faith, and then one of the directors left the company, and he was approached to join a group to acquire the claims, to exploit the claims as part of the new group. And on this occasion, the court held that this was not a situation where the director had taken the corporate opportunity. This one was not taking the corporate opportunity. So what was different about Peso Silver Mines, the court said, was that when the opportunity was made, when the offer of the opportunity was made to the board of Peso Silver Mines, the board emphatically rejected the offer. So the court said, look, it's as if the opportunity never actually belonged to the company, because they had rejected it. And the other aspect of this is that Cropper, the director, left the company, and subsequent to him leaving the company, the offer was made to him and to a group of others. So the court held that the opportunity never really belonged to the company. And the other aspect is it wasn't really, you couldn't say it was only because of the director's position as a director of Peso Silver Mines that he was aware of the opportunity. So the opportunity never actually belonged to Peso Silver Mines. Let me come to the Regal Hastings case, which is probably Regal Hastings and Queensland Mines, the one we'll do after this, the two cases to definitely familiarise yourself with, because Regal Hastings is probably the more complex, but the decision that the court made is quite significant. So we've discussed that a director mustn't take a business opportunity that the company is currently considering or in which it might reasonably be expected to be interested in, given its current line of business. But what about if the company is or would consider the opportunity, but it's unable to actually do anything with the opportunity, and that might be for financial reasons, and that's precisely what happened in Regal Hastings. So in the Regal Hastings case, which is set out in the textbook, the facts are a little bit challenging to get our heads around, so I'll do my best to explain them. So Regal Hastings owned a cinema, and so Regal Hastings is a company. It had an opportunity to acquire a further 2 cinemas, and the intention there was that they could operate as basically a chain, and so they exploit the synergies and economies of scale of operating a number of cinemas. Now, to exploit the opportunity, Regal Hastings created a subsidiary company. So there was Regal Hastings and then Regal Hastings subsidiary. Why did Regal Hastings form a subsidiary? Well, the vendor, the person that they were, or the entity that they were acquiring these 2 cinemas off, said that they would only sell to a legitimate buyer, and they defined a legitimate buyer as someone who had paid up capital of at least $5,000. At least $5,000. The problem for Regal Hastings was that they didn't have, this is a reasonably old case, 1942, $5,000 is a lot of money. Regal Hastings, well, they didn't have $5,000. So they had an opportunity, but they didn't have the capital to be able to take advantage of the opportunity. So where are they going to get the capital from? Well, of the $5,000, they had about, and the other option was for the directors to sign a personal guarantee, but they didn't want to do that. So Regal Hastings had about $2,000. So they're short about $3,000. Where are they going to get the $3,000 from? Well, they sold shares. Who did they sell shares to? They sold shares in the subsidiary to the directors of Regal Hastings. So now we have this Regal Hastings and Regal Hastings subsidiary. Regal Hastings subsidiary has 2,000, is the one that's going to acquire the cinemas. 2,000 of the shares in the subsidiary are owned by Regal Hastings. The other 3,000 are owned by the directors and the company lawyer. So each director took 500 shares, and they paid $1 per share. Okay, so now we've made all of the directors of Regal Hastings are also shareholders in the subsidiary of Regal Hastings. That meant they got to the capital requirement to acquire the 2 cinemas, so they purchased the additional cinemas. Regal Hastings directors then decided to sell their shares in the subsidiary. And remember what they paid. They paid $1 for each share, and they sold their shares because the cinemas had done quite well and were quite profitable. They sold their shares for $3 per share. So they made a profit at $2 per share, or 200% on top of what they paid for their shares. After a while, it came out to the shareholders of Regal Hastings, not the shareholders of the subsidiary, but the shareholders of Regal Hastings, that the directors had made this profit. So they had never actually disclosed the fact that they had taken a holding in the subsidiary. The directors didn't disclose that. So the question here was whether the directors of Regal Hastings had taken an opportunity that belonged to the company. Now, this by comparison to the two previous cases, is a little bit trickier, because remember what we said is that Regal Hastings was unable to come up with the capital. So when the allegation is made against the directors of Regal Hastings that they had taken the corporate opportunity and made this profit for themselves, the response from the directors, their defence, is to say, well, the company was unable to take advantage of the opportunity here. So who wins in this case? Who wins in this case? The court found in favour of the company, but found against the directors, said that the directors had acted improperly here, that they had taken an opportunity that belonged to the company. And it's really the court's reasoning in Regal Hastings makes a lot of sense, and hence why I say it's quite a significant decision from a policy perspective. The court took the view that directors have an obligation to do everything that they possibly can. If they think that an opportunity is worth investing in, then they have an obligation to do everything they can to give the company the best opportunity to take advantage of that opportunity. And that means that they need to go and beg, borrow, or steal to try and get the capital that they possibly can. It's not good enough, the court said, and is not a good situation and would set a bad precedent. If directors could turn around and say, when there was a really good opportunity, if directors could turn around and say, well, the company didn't have enough money in the bank, so the company couldn't take advantage of the opportunity, so we just invested our own money and managed to make some massive profits ourselves. So that was the court's reasoning, and in my view, that makes, even though it's a little bit complex, it seems to make a lot of sense that we don't want to remove the incentives that directors have to do everything they can to exploit an opportunity that the company has. So a couple of things the court considered in Regal Hastings was whether the profit was acquired by reason only that they were a director of the company, and really it was only by reason of the fact that the directors were directors of Regal Hastings that they were able to acquire the profit, and it was obtained in the course of the execution of the office of a director. There is a side note. To Regal Hastings, so that part of it makes sense. But I'm pretty sure if you have a look in the textbook, you see there is a side note to Regal Hastings, which is and has been criticised because the chairman of Regal Hastings was found not to be in breach, and that appears to be because his shareholding was held through companies, so he received his benefit through the company. And interestingly, it was the new shareholder who sued and received the benefit even though it was the old shareholders who probably actually lost out, that they didn't get the benefit of the opportunity. Okay, so Regal Hastings, it doesn't matter, if we summarise, it doesn't matter that the company is unable to take advantage of the opportunity itself. That does not give directors free rein to go and take advantage of the opportunity or take that opportunity for themselves. All right, Queensland Mines and Hudson. This case is also a significant case, just like Regal Hastings. It went to the Privy Council, so most senior court of appeal, the highest court of appeal in 1978. We've got two businesses that sort of came together in a joint venture, which were two families. The Cormans, they had 51% of the shares, and I should mention it's Queensland Mines, it's the name of the company, but the mine was actually in Tasmania. So that's just part of the facts. The Cormans had 51% of the shares in Queensland Mines. They provided the capital. Mr. Corman and his family provided the capital for Queensland Mines. The other family was the Hudson family. The Hudsons provided the technical expertise, if you like, the technical expertise, the geological and engineering know-how. Queensland Mines was in negotiations with the Tasmanian government to explore for iron ore, and it looked as if the government was going to grant the mining rights to the company. So there was an opportunity there that appeared to belong to Queensland Mines. The problem is that the Cormans, depending on which view you take, either got a little bit nervous, didn't think the opportunity was going to become profitable. So the Cormans, remember, they were the ones that provided the funding. They pulled the funding. So Mr. Hudson and Mr. Corman came together. Remember, Hudson's got the technological know-how, the Cormans provide the funding. Mr. Hudson says, well, if you're not going to provide the funding, the project's probably not going to go ahead. But Mr. Hudson said, I'd like to explore the opportunity myself and see if I can raise the capital myself and explore the opportunity. And Mr. Corman agreed that Mr. Hudson could continue with the project. Of course, what happens is that the project did proceed. The Hudsons got the project off the ground and it was profitable. So when the Cormans saw that this mine had actually got off the ground and was actually profitable, they wanted to see if they could get their hands on some of the profit. So how did the Cormans argue this? Well, they said that this was an opportunity that belonged to Queensland Mines, and Mr. Hudson had taken this opportunity. The Privy Council, though, accepted in evidence that there was some sort of an agreement between Corman and Hudson on behalf of Queensland Mines, that Mr. Hudson was free to explore this opportunity, to try to develop this opportunity himself. And so the court saw that as it was as if Queensland Mines had given up the opportunity, had actually relinquished the opportunity. So even though there was no formal meeting on behalf of Queensland Mines, the court accepted the substance there was that there was some sort of agreement that Mr. Hudson could pursue this opportunity on his own. and so the courts accepted that Queensland Mine had effectively relinquished or given up the opportunity. So again, we see this principle, another one of these principles in these cases, that we sort of look for whether the opportunity belongs to the company, whether it's only by reason of their position in the company that the directors have become aware of and been able to make a profit by reason of the opportunity. But another one of these factors the courts have considered is whether the company has actually considered the opportunity and has actually given up the opportunity. And the court's view in Queensland Mines was that the company had actually given up the opportunity, so no breach there. Another one of these corporate opportunity cases is the Canadian Aero Services case. I'll probably just go straight to the issue here. So the court held there that where a couple of directors resigned from the company, so the opportunity belonged to the company, and then they resign from that company and they form another company, the court held that it was a breach. Even though they had resigned, it was their position in the initial company that led them to the corporate opportunity. It wasn't a fresh initiative. So summarise all of that on this slide here, which is our checklist. So the first thing, which I probably skipped over, is to actually identify the opportunity. What is the opportunity? How would we characterise it? Then we need to consider whether the opportunity does in fact belong to the company. So remember, in Peso Silver Mines, the court said, well, actually, it never actually belonged to the company, or if it did, the company had made an emphatic decision that it wasn't going to pursue the opportunity. The Regal Hastings factor that we can take out is that it doesn't matter if the company can actually take advantage of the opportunity. So it's not good enough for directors to say, well, the company didn't have enough money, so we invested our own money in it. That's not good enough. The court said that's not a good enough reason. But the court was willing to accept that the company at times will relinquish the opportunity, and in Queensland Mines the company had emphatically given up the opportunity. And it wasn't so much that in Queensland Mines that the company didn't have the capital, it was that the board had made a decision that they didn't think it was going to be profitable. And so it was, the court on that occasion accepted that the director was free to exploit the opportunity themselves. Of course, it's only going to be an issue, that taking advantage of a corporate opportunity is only going to be an issue where the director has in fact made a profit. If there is no profit made, then it's not going to be an issue. The other issue, which I did sort of skip over, and well, we sort of alluded to in Regal Hastings, but is whether there has been any disclosure. And remember when I introduced this consideration of the conflict of interest, a key aspect is whether the director has actually disclosed their conflict of interest. So remember in Regal Hastings, the directors, we said, it wasn't until after the directors had sold their shares for a profit that the shareholders became aware that the directors were actually in a position of a conflict of interest. If we contrast that with Queensland Mines, in Queensland Mines, the director says, well, if you're going to pull the funding, that director says, well, I'm going to go and try and exploit this opportunity for myself. So that was disclosure. So the key issue then to consider is whether the director has actually disclosed the conflict of interest and the potential for profit. All right, so let's move then to the statutory regulation, which again just codifies all of these conflict of interest principles. So sections 182, 183 and then 191. And we'll come to these here. So the first obligation is the duty to disclose. So where directors have a material personal interest in a matter that relates to the affairs of the company, the director must disclose the nature and extent of the interest to the other directors. Yes, so the key consideration, the key case here is the Magellan and Mount King mining case. The question that often arises when we're considering what should be disclosed is precisely that, is what needs to be disclosed. In Magellan and Mount King mining, the court said the conflict must be of a real or a substantial kind. So when should directors disclose? Well, when they have a conflict of interest which is of a real or a substantial kind. That question, though, is a little bit of a how long's a piece of string question. So the view that I've taken, and this is really where I see the test, is does the conflict of interest, or would the conflict of interest have the potential to influence the way that a director would vote? Would the conflict of interest have the potential to influence the way that a director would vote? Because if it is, if potentially it would influence the way that they would vote, then in my view it is a conflict which is of a real or substantial kind and therefore must be disclosed. So remember last week when I sort of started this conversation about conflicts of interest, and we sort of considered a few scenarios of various directors, and we said, you know, what about directors that sit on multiple boards? So we said, what about a scenario? Would it be possible for a director to sit on the board of the Commonwealth Bank and the National Australia Bank? And we said that's too big a conflict. We said that's not possible. But then we said, well, what about a director sitting on the board of Woolworths and a director sitting on the board of Qantas? Well, the vast majority of matters that Woolworths deals with probably not going to be influenced by matters that Qantas would consider. But so that is probably a conflict of interest that we would say could be managed. But of course, Woolworths has a rewards program that they have with Qantas. So if there was any matter that was where Qantas was, where that rewards program was being considered, if a director was sitting on both of those, and I would say let's apply our test. Would a director sitting on both the board of Woolworths and Qantas, would it potentially influence the way that they might vote? I would say yes, it probably would. We think that a positive outcome for the director that sits on both of those would be influenced as to how they would vote. So that's the test. When we say that interest must be a real or a substantial kind, would it influence the way that they would vote? Now, when talk about section 191, then we need to come and talk about sections 194 and 195. So the duty to disclose, so remember, under the statutes, there is no duty to avoid conflicts of interest as such. The duty is to disclose conflicts of interest, and then we have some duties under sections 182 and 183 about misusing position, misusing information. What about where a director does have a conflict of interest? What do they do? well, the first thing we've already seen is they must disclose that conflict of interest. Now, for some conflicts, that may just be a one-off item that, for whatever reason, has just come up. So they need to give notice ahead of that board meeting. For some other conflicts of interest, it's an ongoing conflict, such as sitting on the board of Woolworths and Qantas. That director would give standing notice under 192, which just means that they give notice once and for all, if you like, so that the company is aware on an ongoing basis that director has an ongoing conflict of interest. What do they do though where they have a conflict of interest? What does it mean? Is it sufficient to just disclose? The answer is not really, although it depends on which type of company. So it's one of the few areas where the law takes quite a different approach, depending on whether it's a private company or a public company. So Section 195, let's look at that first, because then it makes 194 sort of makes a bit more sense. 195 applies to directors of public companies. Where directors have a conflict of interest, even if they have disclosed their conflict of interest, they must not vote and they must not even be present while the board considers a matter on which they have a conflict of interest. Yeah, but that is only the rule for public companies. Yeah, so public company directors of public companies, if there is a matter being considered, they have a conflict of interest, they must not vote and they must not even be present while the board considers the matter. So then we contrast that with Section 194, which applies to proprietary companies. Directors of proprietary companies that have a conflict of interest are allowed to be present, and they are, provided they've disclosed, they are allowed to vote, even though they do have a conflict of interest. Yep. So the default position is that directors of proprietary companies are allowed to be present and are allowed to be vote, even where they have a conflict of interest. But note, as I've got on the slide there, missing an end bracket, but there's a little RR, just note, that's a replaceable rule. So proprietary companies can vary that rule. They might want to change it to make it more similar to what applies to public companies, and they'd be free to do that in their constitution. Yep. So then let's have a look at 182 and 183 in detail that deal with these conflicts of interest. So a couple of points to make. A lot of similarities between 182 and 183. I've highlighted the key difference there. So 182, directors must not improperly use their position. 183, directors must not improperly use information, so information that they have gathered by reason of their position. Yeah, so one relates to the position, one relates to the information. So these two are very similar. They are distinct, okay? But this is one of the few times I would say that unless in the particular scenario that you're dealing with, it looks a little bit funny, I would probably put these two together. It's so remember all the other duties I've said, oh, they need to be dealt with separately. I still think you need to make out, look, you still need to make out whether it is a misuse of their position or misuse of their information, so you should still try to do that. But I think it would be okay to deal with them together, and the reason for that is the test is the same. So if we have a look at the test that comes from Grove and Flavelle, the test is, would a reasonable director consider it to be an appropriate use of their position in relation to 182? or would it be an appropriate use of information gathered by reason of their position? So most of the time you would put these two together. Sometimes there are some cases you'd say, well, clearly there's a distinction between the two, but most of the time we see, or a lot of the time we see these two sections run together because there's such an overlap between them. Some cases look very similar. The court emphasises 183 more than 182, but that's just the way it is. So if we have a look at ASIC and Vizard, which is the 183 case, the court emphasised more 183 that it was a misuse of information, but clearly it was a misuse of position as well by Steve Vizard. The other aspect of 183, or both 182 and 183, is if we see who it actually applies to. 182, 183 applies to directors. It also applies to officers. It also applies to employees. So employees must not misuse their or improperly use their position or information that they've gathered. Just the last point I'll make before we look at some of these cases is that with 182, 183 is you can't improperly use your position to gain an advantage for yourself or for someone else. You can't do it to gain a benefit for yourself. But there are some cases where ASIC can say that the director has done the wrong thing, but they can't necessarily point to a benefit or an advantage that the director has gained. So the other aspect of 182, 183 is you can't misuse your position or information to gain a benefit, but you also can't misuse your position or information to cause harm to the company. So you can't do it, you can't misuse your position or information to cause a detriment. So that's the second point here. That's what I'm getting at here. You can't use it to cause a detriment to the company. And just keep in mind that test. All right, let's look at some of these cases. With the High Court case, the R and Burns and Hopwood. This was a criminal case, and we know it's a criminal case by the use of the R. So it's the Crown and Burns and Hopwood from the mid-90s. In this case, we've got two directors. Oh, sorry, that thing's not working. Burns and Hopwood were the directors of a company called Jeffcott Investments Limited, and that company had $4.2 million in debts outstanding. They had entered into these merger negotiations with a company called Magnacrete, but they wanted to pay down the debt of Jeffcott before the merger proceeded. So how are they going to do that? Well, they were going to issue new securities or raise capital to pay down the debt. If we have a look at the next slide, sorry, the previous slide there. So remember that Burns and Hopwood are directors of Jeffcott, but they are also directors on the Magnacrete board. So a bit of a conflict of interest that we've got a merger going on between two companies, and we've got Burns and Hopwood, pretty key players with Jeffcott, but they're also key players with Magnacrete. And so remember they said they wanted to pay down this debt. How were they going to pay down this debt? Well, they were going to issue securities. The problem is that they needed someone to to underwrite the issue of securities, right? Get to an underwriter, it basically guarantees that the issue will proceed. Well, who did they get to guarantee or to underwrite the issue of securities? Well, they got Magna Creek to underwrite the issue of securities. So massive conflict of interest that they were in this situation, and they got Magna Creek to underwrite the debt. And the court said that Burns and Hopwood had improperly used their position as directors of the Magna Creek board to do what they did. The other aspect of this case was that the underwriting was not actually considered by the Magna Creek board. So how did the Magna Creek board get authorisation to give authorisation to proceed with the underwriting? Is that the directors, Burns and Hopwood, just took the company seal and applied it. So there was no authorisation from the company. They just applied the company seal. So they had misused their position, and the court said it was really fraudulent what they had done to use the company seal in that way. And so that was hence why this case was considered as a criminal matter. So they didn't tell the other directors what they were doing. All right, so now we touched on the ASIC and Visor case a few weeks ago. Remember, this was the case where Steve Visor improperly used his position. He was a non-executive director on the board of Telstra. He found out that Telstra was going to make large investments in three companies: Computershare, Sausage Software, and the one that I always forget. Anyway, he got his stockbroker to go and buy shares in those companies, and of course, a few days later, a few weeks later, when Telstra then goes out and actually makes the investments, the price of those shares goes up. And the court held that this was a breach of Section 183, that he improperly used his position, improperly used information. This case, of course, looks like insider trading, and in fact it is insider trading, but ASIC ran it as a Section 183 case, misuse of position and misuse of information. The reason for that is that the law around insider trading has changed quite a lot in recent years. Back then it was quite challenging, and in fact I think they'd only actually successfully prosecuted about 4 or 5 insider trading cases. So it was easier for ASIC, they felt, to get a conviction under the sections 182 and 183, hence why they ran it under those cases. We'll have a look at insider trading. Remember the ASIC and Adler case that was, we considered ASIC and Adler under section 180. You'll see that the court considered was also a breach under section 182. That Mr. Adler improperly used his position. All right, we're going to, in the next lecture, go through some of these remedies. So let's, how about we leave it there? I'll let it, and that might actually be a good time to pause. So if I resume talking at 5 o'clock, according to the clock on the back wall there. All right, let's resume, and we'll make a start on this lecture. We won't get through all of it, but the main thing is to cover off on the remedies. So we've talked about the breaches of, well, we've talked about directors' duties. Where there is a breach, we need to consider what the remedies are that are available. But then in this lecture we'll also cover the rights of shareholders, or what protections there are for shareholders, and what remedies shareholders can seek where they feel they have been wronged by someone else. It might be a minority shareholder feels that the majority shareholder has wronged them. And we'll touch on some of the issues for shareholders' meetings. So who is it that can, sort of picking up from where we left off that last lecture, so what are the remedies and who is it that can actually seek the remedies? So the statutory remedies can be enforced by ASIC or the company. The general law duties really only apply for the company. So ASIC can seek remedies, or the company can seek remedies. We'll see when we talk about the remedies that the remedies that are available are different depending on who seeks the remedies. The other curious thing, we'll explore this in more detail, is that to bring an action under the Corporations Act, you must have what is called standing. What's standing? So standing, as far as the courts are concerned, is the right to bring an action. The right to bring an action. So who has standing? So we've said ASIC and the company. Now ASIC, that's fine. We'll see with ASIC that ASIC does not have to litigate, prosecute every time it considers that there is a breach. It will be bound by, it's limited by the resources that it has available. So it is physically unable to investigate and then prosecute every potential breach of the Act. So ASIC will be guided by what it sees as priorities, where there is significant harm, where particularly vulnerable citizens have been wronged, that it considers that it could actually act. So that's fine. But what about the company? Now this is a curious thing. So who is it that has standing? As we said, ASIC was also the company. The company, who is the company? Ordinarily that means the board. And remember we talked about this a little bit when we talked about section 198A and we looked at the John Shaw case. Yeah, remember there was that litigation power where the board wanted to sue some of the directors on the board. Shareholders didn't want to sue. And who won that? Was the board. The court said section 198A doesn't give that power to shareholders, so it's a board of directors power. So when the Corporations Act refers to the company, it generally refers to the board. Yeah. Now that's a little bit, seems a little bit peculiar, because what have we just been talking about? We've just been talking about directors' duties. So where directors have breached their duties, if ASIC doesn't bring action against them, who can bring action against them? Well, the company can bring action against the directors. But who is the company? Directors, the board of directors, that's right. So is the board of directors likely to bring an action against themselves? Yeah, that seems a little bit bizarre, exactly right. But that's the way the law is written. So how do we deal with this situation? Well, if we've got a situation where one director on a board of many, of a number, has breached the Act, then the board may bring an action against that one director. Right? But what about if it's all of the directors on the board have breached? Is the board likely to bring an action against all of them? Of course not. That would be silly. So, but that's the way the law is written. But the law adds one more provision, which is section 236, which is the statutory derivative action, and it deals precisely with this scenario and says that where shareholders feel that the board is unlikely to act, then shareholders can themselves make an application to the court to bring an action against the directors. Yeah. So it needs to be a serious matter that's being heard. So breach of directors' duties would be a serious matter. And they also need to provide, shareholders need to provide notice to the company to say, look, we think this matter should be litigated, and if you don't bring an action within 14 days, and that's the time frame, 14 days, then shareholders will bring an action themselves. Okay. So what are the remedies? So the remedies that apply are pretty consistent. The civil penalty regime applies for sections 180 to 183 and 588G. The court needs to make an order, or what we call a declaration of a contravention. The court orders that there has been a contravention. Where that applies, the court can then order any of the three remedies. So the penalty up to $200,000, disqualification order under 206C, or a compensation order. So remember, we talked about directors can be disqualified. So that's what we meant. We talked about disqualification order or the compensation order. Now, those remedies are all available to ASIC. ASIC can seek any one of those three remedies. We'll see that the only remedy that's available to the company or to shareholders under the derivative action is the compensation order. Yeah. Now, ASIC, we said they don't have to litigate every matter. ASIC may decide, or it may, be careful about how this is worded, ASIC may accept what we call enforceable undertakings under section 93AA of the ASIC Act. And that just means the company or the director provides a written statement that says, look, we are going to put in place certain measures. We accept that we've done the wrong thing here. We are going to put in place certain measures, and that might be that they tell all their directors and senior officers to undergo an education program, something like that. So we're going to put in place certain processes to ensure that this doesn't happen again. So that's what we call an enforceable undertaking. If it does happen again, then ASIC can go to court with the enforceable undertaking and say, look, they said it wouldn't happen again, it has happened again, and now they can ask the court to take action. Yeah, so that's another avenue, which is like, this is the enforceable undertaking avoids going to court, avoids the process of going to court, and again, it comes down to the sort of priorities. This is an area, though, where ASIC did come under criticism, and and I suspect ASIC will change the way that it enforces the Corporations Act going forward. So it came under criticism in the recent Banking Royal Commission. So the criticism that was made of ASIC was that it avoided going to court and was too ready to accept enforceable undertakings. So where banks had done the wrong thing, they would just provide a letter, an agreement, an undertaking to ASIC and say, sorry, we did the wrong thing and won't do it again, and avoid the matter being litigated. And they could, with enforceable undertakings, they may just pay an infringement notice, which is another remedy that we don't, sort of a more modern remedy we don't sort of focus on too much, but yes, they can just pay a very small amount, nothing by comparison to what those pecuniary penalties are. So ASIC has been criticised. I strongly suspect going forward that ASIC will be more inclined to litigate where they see that there is the wrong thing, and in fact tonight, in the budget that's being handed down tonight, I strongly suspect that the Federal Treasurer will provide funding to ASIC precisely for this matter, to actually litigate more matters rather than just accept enforceable undertakings. Yeah. Okay. Note that we also have criminal remedies. The sections 181 to 183 can be criminal matters. Just note that section 180 is not made a criminal matter. So section 181, 182, 183 all can be made criminal. Where they're made criminal, they come under section 184. So section 184 just replicates uses the same language as 181 to 183. It just makes them criminal matters. So what's the difference between criminal and civil? Well, the big difference is the standard of proof. Yeah. So ASIC doesn't run every case as a criminal case. It runs the majority of cases as civil cases, but it does run some criminal cases. So what do we mean standard of proof? So that means that remember when you did this in commercial law, when ASIC goes to court, they have to prove their case to a certain standard. What is that standard? For civil matters, it's the balance of probabilities. Just needs to be more than 50-50, really. Whereas for criminal matters, so if ASIC chooses to run a case as a criminal matter, what's its standard of proof? Those of you who watch American murder shows or crime shows, beyond reasonable doubt. Beyond reasonable doubt is the criminal standard. So that's why, even though ASIC, so what is beyond reasonable doubt? Well, it's something far greater than 50-50, something close to 100. That's why ASIC will more likely than not run a case as a civil case. If there's anything in its case that it has a question mark over, then it would just run it as a civil case. Section 180 is not made criminal. The other aspect, though, is the actual test that we apply. So the standard of proof is different, but the test is the same. Okay, the test is the same. So the test. Remember we talked about a moment ago for sections 182 and 183 is whether any other reasonable director would consider it an appropriate use of their position. Yep. So that test is the same, it's just the standard that we have to apply. The Section 181 tests, duty to act in the interest of the company. Is there a benefit that flows to the company? So it's the same test. What does that mean for our purposes? For our purposes, if you're given an assignment question or an exam question, you can only go on the facts and take them as given. We can't really realistically consider the standard of proof in an exam question. So all we can say is that we can apply the test. Yep, we can do that. And then we would say, look, it could then be considered as far as remedies goes, either a civil or a criminal once we've made out the test. I mean, there is the other aspect, of course, to a criminal matter, that you have to generally show that the director or officer has actually intended to act dishonestly, yeah, or fraudulently. Yeah. So there's the potential for jail for criminal matters and the higher financial penalty. And in insolvent trading is also, I've just noted there, a criminal matter as well under 588G3. Okay. The remedies that are available under the statutes for the company, the ones that we typically talk about are the compensation remedy. So that's a member of those three remedies. We talked about compensation. Compensation is the only one that's available to the company. Obtain any profit, well, that would largely be covered by compensation anyway. The only other one there I'll just mention is if you know in advance that a director is likely to breach the Act, then you can get a thing called an injunction, which was an equitable remedy, but now comes under Section 1324 of the Act. Which is if you know that a director, or you consider it likely that a director will breach the Act, you can go to court and ask for an injunction to stop them from breaching the Act. And then if they then breach that court order, they are then in contempt of court, which can then be punishable by jail. So that's quite significant, a significant remedy as well. So that slide there just sets out the remedies for under the common law. So we just talked about injunction. Compensation is where there's a breach causes loss to the company. An account of profit. So if a director makes a profit because of a breach of fiduciary duty, it may have to pay that profit to the company. So the examples there are in the Regal Hastings case that we just talked about. As well as the Canadian Aero Services case, where the directors made profits, then they have to give an account of profits. Rescission of contract just means that the contract's basically terminated, or constructive trust. I'll let you look at those in your own time. Okay, so what about the general principles applying to the equitable remedies? So the company must not unduly delay bringing proceedings against the director. The company must not be guilty of misconduct in relation to dealing with the director. And if the company or the members later agree to the transaction, the company will not be able to later sue the director. The court can excuse a breach of a statutory duty, so it can be in part or in whole. The court can also excuse a breach of the general law, and I'll look at that ASIC and Vines case here. So in ASIC and Vines, ASIC alleged breaches of Section 232(4), which is of the old corporations law, which is now section 181(1) of the Corporations Act by Mr Vines and 2 other executives. And it related to a profit forecast, so the communication of the profit forecast, and the Supreme Court found that there were several breaches, some of which were overturned by the Court of Appeal. But the Court of Appeal accepted the Supreme Court's approach to relief from liability, which is what we're considering here. And the approach there was that even though Mr Vines had acted honestly, he shouldn't be excused from liability. So that so there are relevant circumstances that the court highlighted where it will accept relief from liability and then when it won't. So those are set out, I'm pretty sure, in the textbook. So a company can ratify a breach of the general law duty, but it must have all of these. So you need an ordinary resolution of shareholders to ratify a breach. The shareholders must have all the necessary information, and the notice of the meeting needs to clearly set out that the members are going to be asked to ratify the breach and waive their right to sue. It has to happen in a reasonable time, and where where individuals are alleged to have breached, then they can't actually vote. And there are further limits on shareholders' power to ratify a breach. So situations where shareholders will be unable to ratify a breach, where it's oppressive, and we'll talk about oppressive conduct probably after the mid-semester break. The result would be prejudicial, breaches the equitable limitation, which we'll also talk about, or results in a personal right of a member being eliminated, or results in the misappropriation of the company's property. The members have acted for the same improper purpose as the directors. Okay, directors can get some protection from liability by way of insurance and indemnification. So it is available, but a company mustn't pay premiums for a director or officer against a liability arising out of conduct involving a willful breach of duty or a breach of sections 182 or 183. And section 199A says the company or related company cannot indemnify the director or officer breach of duty except in relation to costs for a defence or the liability is to another person, and the director doesn't lack good faith. All right, let's look at some of these shareholders' remedies beyond those which we've already considered. Yes. Let's go straight to that. Let's go there. All right. So shareholders' remedies may be available where officers have breached their duties, but as I've noted there, sometimes shareholders can also obtain a remedy even though there hasn't been a breach of the duties. So there's a few of these remedies available. So the first of the remedies that I want to talk about is the oppression remedy under section 232. So the oppression remedy is a very broad remedy, and it arises frequently. And the reason that it arises frequently is because it is such a broad remedy. It's also the sort of remedy that, because it is so broad, you could almost attach it to any action that you bring. So it's a bit like, remember when you did consumer law, there's all of the specific breaches of consumer law, but then there's also just the simple misleading and deceptive conduct. And you would almost always attach a misleading and deceptive conduct claim to just about anything that happens in contract, in commercial law. because it's so broad and so general. So oppression remedy is a little bit like that. It applies in anything, if we have a look at section 232, it applies to anything in the conduct of the company's affairs, or an actual or proposed act or omission by or on behalf of the company, or a resolution or a proposed resolution of members or a class of members. So that covers any decision basically of the board of directors, or any resolution that's been considered and decided upon in the shareholders' meeting. So if you think about it, in the life of a company, what else is there? There's probably not a lot else that actually happens in the life of a company. So shareholders, anytime they feel that they've been wronged, could actually bring an action under section 232. What does it mean to be oppressive? So the conduct under section 232, it simply says the conduct complained of is contrary to the interests of shareholders as a whole, or is oppressive to, unfairly prejudicial to, unfairly discriminatory against a member or members. And the Morgan and 45 Fleurs Avenue case, which I've noted there, the court there suggested that it should actually be read as a composite, as different aspects of the essential criterion of commercial unfairness. So anything, so the oppression remedy applies to anything that's commercially unfair. So again, it's exceptionally broad remedy. Who can apply? Well, it's generally for shareholders. One of the things they will see with oppression is that shareholders are not restricted to bringing the case in their capacity as a shareholder. So remember we talked about the statutory contract under section 140, where we said they were restricted to bringing the action in their capacity as a director or a shareholder. With the oppression remedy, you're not restricted to bringing it in that capacity. So provided you are a shareholder, or you've recently been removed from the register, or you will cease to be a member if the oppression action occurs, or ASIC thinks that you will be affected, then you can apply. So generally it's for shareholders, but not limited to their capacity. Then we come to the test for when oppression will apply. And I should mention that the test, which does happen a few times in corporate law, the test is not exhaustive. So if you can apply the test and say, well, yeah, no other director acting reasonably would have done this, which is what the test is, we'll see, doesn't on its own mean that there is oppressive conduct. But it may very well be. So it comes from, of all things, it comes from the rugby league. This case. So Wade and New South Wales Rugby League. Let's talk through the facts of the case. We've got a sporting competition, the rugby league. The rugby league was, or New South Wales Rugby League was expanding. The problem was that they had the vast majority of the teams were based in fact, most of them were based in Sydney, a couple more in broader New South Wales, but they wanted to make the competition a national competition. It's not a very national competition if the vast majority of the teams are based in Sydney, and in fact there wasn't even one in Brisbane at the time. So How was the New South Wales Rugby League trying to expand the game? Well, they were trying to expand into Queensland. But the problem was there wasn't enough playing talent. That was the fear. Well, fearful that if they had too many teams, that the competition would be too weak. So they had to get rid of some teams. So that was the proposal. They get rid of some of the Sydney teams, and then they could introduce more teams from other parts of the country. So, as I know there, 1982 was when Canberra Raiders and the Illawarra Steelers were added, which made 14 clubs or 14 teams, and they wanted to reduce the competition. So they tried to get rid of Newtown, which they did in 1983, and they also tried to get rid of West for the 1985 season. What does all of this have to do with corporate law? Is the way that the New South Wales Rugby League was set up was it was incorporated under the Corporations Act. Hence the Corporations Law at the time. Hence the Corporations Law applied. Each team or each club in the competition had one share. So, and those are all the shareholders in the New South Wales Rugby League Incorporated. So how were they actually getting rid of these teams? Well, the way that they did it was to cancel their shareholding. So they said, right, you've got one share, we're now cancelling your shareholding. Now, if you had shares in BHP or Commonwealth Bank or Woolworths or Qantas or any of these other companies that I've picked on tonight, if you had shares in any one of those companies and you got a letter tomorrow from the board of Qantas or from the board of BHP to say, look, we think we've got too many shareholders, so sorry to do this, but we're going to cancel your shares. Really sorry to do that. What do you think? What would your response be? You'd be like, well, you can't do that. And one of your remedies would be, you would say, this is oppressive conduct, right? This is oppressive. And most likely that would actually be oppressive conduct. But in the context of a sporting organisation, in the context of Wade and New South Wales Rugby League, the court actually said that simply cancelling shares in this case was not oppressive conduct. Why not? And the test the court applied was whether the director's decision was one that no board of directors acting reasonably would have made. So was this a decision that other directors acting reasonably could have actually made? And the court in Wade and New South Wales Rugby League said, well, in fact, we can see what the board is trying to achieve here. We can see that the league, the incorporated entity, is trying to grow the game. And I've got this quote here from the judgment. The answer to this contention is that no amount of sympathy for West, remember West that was the poor club that was getting picked on. Incidentally, West survived. They were allowed in anyway, in spite of the fact that it went to the High Court. The answer is that no amount of sympathy for West can obscure the fact that the league was expressly constituted to promote the best interests of the sport and empowered to determine which clubs should be entitled to participate in competitions conducted by it. And it was on this basis that the clubs, including West, chose to incorporate. Indeed, the 1984 correspondence between West and the League, which is in evidence, plainly shows that West itself fully appreciated that it had no secure right to participate in the premiership competition. So that was the reasoning. So the court said yes, you can cancel shares on this occasion, but only because of the unique situation that the rugby league was in. New South Wales Rugby League was in. Okay, so our test then comes from Wade and New South Wales Rugby League, but remember it's not a rigid test. So you would always, any time that there is an oppressive conduct issue, you would apply this test, you would consider it, but we'll see that there are a number of other oppressive conduct cases. And so I'd say have a look at these other examples of oppressive conduct and see if the factual scenarios do actually align. Yeah, because if you can align it with one of these other factual scenarios, you may still have a case. So there is no really rigid test. There's other cases, such as Morgan's case, which we'll come to, and Tivoli. Okay, so let's move on. Okay, so some of the factual scenarios, we'll talk about some of these that have, where the courts have said that there was or there may have been, or the courts have considered whether there's oppressive conduct. It involves the diversion of business opportunities, improper exclusion from management, unfair restriction of dividends, oppressive conduct of board meetings, share issue for an improper purpose, breach of directors' duties. So I just note these last couple. So Kokotovic, remember the Kokotovic case, we referred to that in relation to the director's duty not to act for an improper purpose. So Kokotovic was actually a breach of director's duties under section 181, 1B. But the court also considered whether it was oppressive conduct. Yeah. And in the Rees-Spargos and Jenkins cases, which we may come to, this case was a breach of directors' duties to act in the interests of the company that they are a director of, but it was also considered as oppressive conduct. So just keep that in mind. All right, so let's have a look at some of these cases. So in Hogg and Dimmick, the significance of Hogg and Dimmick, remember the point that I made before, was that, yes, oppression is a remedy really for shareholders, but you're not limited to bringing the remedy in your capacity as a shareholder. So if you are a shareholder, you might feel that you've been wronged in relation to your participation as a director. Provided you are a shareholder, you can bring it as an oppressive conduct case. And that's precisely what happened in Hogg and Dimmick, where we have three directors. We have a husband and a wife held 50% of the shares together, and then there was a third director, and that other director held 50% of the shares. The husband and wife were each a director. Okay, so we ended up with three directors on the board. So what do the husband and wife do at the board meeting? Well, they gang up on this third director. The husband and wife, because they control the board with two directors versus one, they control the board, so they voted at a board meeting to remove this other director. Yeah. So this other director feels wronged. They feel wronged. So remember, the capacity in which they feel wronged is as a director, not as a shareholder. But they brought an action under the oppressive conduct and the court accepted that argument, even though they weren't bringing it in their capacity as a shareholder. The fact that they were a shareholder gave them standing. Yeah. So on this occasion, the court held that there had been a common expectation of continuing involvement of the plaintiff. So it's almost like it's a test on its own. If you can show that there has been an expectation that someone would continue on in a particular role, then that would be oppressive conduct. Then we come to the Thomas and Thomas case. This dealt with a company who had noted their fairly conservative financial management, and it only paid small dividends, didn't pay lots of dividends. Paid small dividends. The plaintiff wasn't happy with that, and they wanted to force the company, if you like, to pay bigger dividends. And they actually brought a shareholders' resolution to invest income invest in income-earning investments to increase dividends to shareholders. This was rejected, and they sued. The matter went to court, and they argued that the low payment of dividends was oppressive conduct. And the court held here that this was not oppressive. So the low payment of dividends, the courts have said, is not oppressive. However, if you could show, and we go back to the Hogg and Dimmick case, if you could show that shareholders had some reasonable expectation that they would be paid a higher dividend, then you might be able to argue oppression. So let's put up an example. If a company was being floated on the stock exchange or something like that, and they said, look, provided that we meet our profit targets, we will pay a dividend of 50% of profits or something like that. In that situation, that does sound like there is an expectation that shareholders would be. So if the company then met its profit targets but failed to pay a dividend, then you'd have a reasonable argument that there was an expectation that they would be paid, that shareholders would be paid a dividend. I mean, ultimately, dividends are a decision of the board of directors, and the Corporations Act has gone very much that way as it's evolved to say that the payment of dividends is very much at the discretion of directors. But if you could show some sort of expectation, you might have a better argument. Let's move on. In the John J. Starr case, in this case, we have a company which is established to conduct the business of franchising real estates. The plaintiff was a franchisee and a shareholder and a director. Now, they felt that the board had not been provided with a proper budget, and that there was some fairly silly things going on where they were being provided insufficient notice of significant matters that affected franchisees. They didn't have enough time to talk, and decisions were being taken without reference to the board. Well, even though this was a shareholder, again, they were arguing in their capacity as a director, really, that this was oppressive, and the court accepted that. Yep. The Spargos case, which I alluded to earlier, in this case, so just to get a bit of background here, this case involved a takeover. So IRL had taken over Spargos and Enterprise. Spargos and Enterprise both had considerable assets when they were taken over. So the key to this case is that it wasn't a 100% takeover. So they got over half of the shares. So IRL obtained over half of the shares, but not all of the shares. But what they basically did was to, because they controlled now these companies, is they tried to strip out some of the assets of these companies that they'd taken over, even though there were still minority shareholders. So these companies had a lot of assets, and they paid less through the takeover than what the total of those assets were. So they tried to strip out all the assets. So I don't think I included them there, but just for example, Enterprise provided a loan to IRL, and that loan was never repaid. Spargos acquired the shares of another company within the IRL group and paid 3 times the value. So all of this, so why would Spargos and Enterprise be paying 3 times the value for shares? Well, it was trying to get assets out of the company. There's a few other examples. In fact, the textbook summarises some of those examples. So this was the directors of Enterprise and Spargos were found not to be acting in the interests of the company that they are a director of. So breach of their directors' duties, but it was also, as far as the minority shareholders goes, oppressive conduct. So a series of breaches of directors' duties, but also oppressive conduct. We'll pause shortly for the evening. So then the Cassegrain case. In this case, the company sold shares undervalued to a person who was a relative of 2 of the directors. There was no independent valuation and no consent of the minority shareholders. So what orders can the court make for oppression? It's a non-exhaustive list, which is quite curious. There is a list, and the list includes things like the court can order that the company, where there is oppression, the court can order the company be wound up, modify or amend the constitution, regulate the company's affairs, purchase the oppressed shareholders' shares, commence or defend legal proceedings, appointment of a receiver, or stop someone from doing something, so an injunction. But it's a non-exhaustive list, so where there is oppressive conduct, the court can make any order that it considers appropriate. I'm looking at the time, so maybe we do pause there and talk through some of those remedies after the break. All right, very good. Let's leave it there. So I'll post the assignment question this week. So I should have covered this at the start, but anyway, reports we're finalising the marking this week, the reports. Well done everyone with those, for getting those in. Look, let me say that the results will be up by Monday morning. They might be up over the weekend, but I'm only for sort of do a little bit of just checking and everything. They should be done by first thing Monday morning, hopefully the weekend. The assignment question will be up this week, so keep an eye out for that. Other than that, have a good break, be safe and all of that sort of thing. And I'll see some of you in tutorials and the rest of you in a few weeks' time.
is the director and he had the knowledge, extra knowledge.
Yep.
So he said that he had the duty of, it was negligent of him that he did not give the report, he did not verify the report properly. So I was like, what if he did verify the report? He did, according to him, it was fine. According to him, yeah. What if according to him, it was fine? He checked the report and all, but then later something happened and then the market was against him and everything. So in that, would we say that he was wrong?
If he had a particular skill or expertise, then I think you'd argue that he was. And remember, it's not negligence. The issue is whether he's breached